on this morning's docket. Case number 111044, State of Kansas v. Parker.
May it please the court, Peter Meharry on behalf of the appellant, Daniel Parker. I would request 3 minutes of my time for rebuttal.
3 minutes is granted.
Thank you. In this case, Mr. Parker was convicted of felony murder and criminal discharge of a firearm at an occupied dwelling. He was sentenced to life without parole for 20 years and then a concurrent 59-month sentence for the criminal discharge conviction. The case arose out of an altercation Mr. Parker was involved in on a New Year's Eve at a bar. Subsequent to that, he went home and the state's evidence was that he found the club that the individuals that he got in an altercation with were at and shot multiple rounds at the building, killing one individual. In this case, we have raised one issue, and that is prosecutorial misconduct. Specifically, it has to do with how the jury was to consider lesser included offenses in this case.
Can we back up here just for a moment? The legislature amended the statute that allowed for lesser included crimes when it pertains to felony murder to say that there are no lesser included crimes for felony murder. And that took effect July 1st, 2013. And this trial took place some 6 weeks after that law took effect. Is that right?
That is right, Your Honor.
Was there any discussion about the inclusion of lesser includeds not being the law, in fact, actually not supported by the law at that time?
I believe there was discussion between the court and counsel for both the state and Mr. Parker about that. I know the court went through kind of the changes over the last couple of years as to lessers with felony murder. The court, I believe, came to the conclusion that eliminating lessers is a substantive change and could not be applied retroactively. This took place in 2013, August 2013. We certainly understand that this court came out with Todd this year in 2014, where this court found that that change could be applied retroactively without violating ex post facto laws. From our standpoint, we believe that this court should revisit Todd, looking at whether or not it is in violation, applying that statutory amendment retroactively is in violation of ex post facto laws. Particularly in this case, I think it highlights why we believe it should be found that it cannot be used retroactively. In this case, Mr. Parker's only defense was convict me of the lesser included second degree. This wasn't a case where he said, I didn't do it, got the wrong guy. He essentially admitted, I shot up the building, somebody died. His argument to the jury, and his counsel's argument to the jury in closing was convict me of the lesser. Retroactively applying that statute to him takes away that defense, takes away his only defense in this case. So we believe that when you look at how do you determine whether or not a law violates prohibition against ex post facto laws, we talk about whether or not the law makes what was formerly innocent conduct criminal, or it enhances the sentence after the fact. But a third thing is, does it take away defenses of a defendant? In our position in this case, it certainly did. It took his only defense away. So for those reasons, we believe Todd should be revisited.
Did you ask us to do that, though? I don't think you did.
We did not file a 609 letter after Todd came out.
Okay, but I understand your point. Okay.
Sure.
Thank you.
So the court did discuss the changes to the felony murder statute, and it came to the conclusion that lesser should be given in this case. Specifically, it gave the lesser of second-degree reckless and involuntary manslaughter. The problem we have with the comments of the state is we believe they misstate how a jury should have considered those lessers. And the state said the point being that you only look at second and you only look at involuntary manslaughter if you have found the defendant not guilty of first degree. Later on in rebuttal closing arguments, the state said you only look at the lessers if you find him not guilty of murder in the first degree.
Is there a functional difference between saying that, and I understand what you're saying, that basically that compels a jury to find a unanimous decision before considering the lessers, and we've said you can't do that. But is there a functional difference between saying, which we have approved language, you have to first consider the primary charge, and if you find them guilty, then you don't need to do anything else? Is there really anything different about that than saying them not guilty?
I believe there is, because if you say you consider the greater first, but then the state of the law is if you cannot agree that he is guilty of the greater, you move on to the lessers. Where this statement inserts, we believe, a requirement that the jury come to a unanimous conclusion that he is not guilty. Right. Not just a disagreement, but
I guess my question is saying that if the prosecutor would have said, if you first consider felony murder, and if you find them guilty of him guilty of felony murder, you don't need to move on. What's the difference between saying that and what he said?
I think the difference is, the state can say if you find him guilty of felony murder, you're done. But that's not what the state said.
I understand.
So I think the difference is it did not provide for that option of where there is disagreement, then you consider the lessers. The state's argument to the jury is you have to have unanimous agreement as far as the felony murder, guilty or not guilty, before you move on. We believe that's not the state of the law.
If the vote was 11 to convict and 1 to acquit, what would the jury mark on the verdict form?
I believe in this case, with the way the state talked to the jury about how it can include lessers, I don't think, from our vantage point, I don't think they would have gotten to the lessers.
No. My question is, if the sole count was felony murder, and the jury deliberated, and 11 says we want to convict of felony murder, 1 says we want to acquit, and they had a verdict form, what would they mark? They would mark not guilty, wouldn't they?
Presumably.
And so if they cannot agree, say 11-1, which you agree is a correct statement. If you cannot agree, then you move on. That's the same as not guilty in some instances, because they're instructed that they can only find guilty if they're unanimous for guilty. If they can't agree, then the verdict is not guilty. And so what we're asking is, why isn't stating it as not guilty the same as stating you can't agree?
I think the concern we have is if you have a situation where there is 11 to convict, 1 says no, they may mark hung jury, not come to an agreement. But I think with what the state is telling them, they don't even get to consider the lessers, because the state is saying you have to be unanimous before you consider the lessers. So if you've got 11-1, the instructions and what the jury should be doing is saying, okay, we cannot agree on the greater, let's move to the lesser. But by the state saying no, you have to get to a unanimous decision on the greater before you get to the lesser, then the damage here is that Mr. Parker never had the jury consider the lessers.
But why would he want it if he got a not guilty verdict on the greater? I mean, that doesn't make any sense. You're saying he was deprived of having the lesser considered when the outcome without its consideration would have been not guilty, period? That doesn't make any sense.
We can presume they may have come to a hung jury, or we can presume
which would
just
be
as
no
well
harm
that
to him.
But we can also presume just as well that, okay, we've got to come to unanimous verdict, okay, the one holdout says, okay, I'll go with felony murder.
What you're really saying to us, if I'm hearing it, is that a hung jury is not the same as not guilty. Is that what you're saying?
What I'm saying, Your Honor, is the problem we have with what the state said is it foreclosed the jury from considering the defense of Mr. Parker.
That if they're hung, but what you're saying, I think, is that if they're hung on the primary crime, here first degree, then they're to consider the lessers. But that doesn't mean that if there were no lessers, they would mark not guilty. They would just advise the court that they were hung.
Presumably, if they were hung on the grader and there are no lessers, presumably they would come to a hung jury. But in this case, they were in fact instructed on lessers. And again, going back to the defense of Mr. Parker, his defense was convict me of the lesser. And it's the way the state worded their arguments to the jury, that the jury was improperly told how it can consider Mr. Parker's defense in this case.
Are you saying the argument was coercive?
Yes, we think that when the state gets up there and says, this is how you do this, that is pushing a jury to do what the state is telling them. Specifically in this case, that you don't consider lessers unless you come to a unanimous conclusion that he is not guilty of the greater. So we think that does push the jury away from what it should be doing, where if there is disagreement on the greater, then they should consider the lesser.
But the word unanimous does not appear in the argument, but based upon your colloquy with Justice Johnson, it sounds like you're arguing it is inherent in the way that the court or the prosecutor stated it.
I do believe that saying you have to acquit, I believe inherently says you have to be unanimous. And I think if you look at the instructions, the jury is instructed to get to a verdict, guilty or not guilty, they have to be unanimous. So I think it is inherent, unanimity is inherent in what the state said.
Assuming that we accept your argument and find that there was prosecutorial misconduct, in light of our decision of Todd, if we don't revisit it, how do you get a new trial? Because on remand, he wouldn't be entitled to the lessers anyway, would he?
Well, if you don't revisit Todd, we believe a couple other reasons why that the court should, if it is remanded, should still give lessers. One reason was we believe it's law of the case at this point. The state was there when they discussed this. The state did not object. They did not appeal. The trial court made certain findings, and we believe that has become law of this case. One other argument we would, and this isn't necessarily going to ex post facto, but this court in Gleason addressed the U.S. Supreme Court decision in Beck with regard to, in that case, the Alabama legislature had eliminated all lessers for capital murder. And the U.S. Supreme Court said that type of situation violates due process.
Wasn't that because it was a death penalty? I'm pretty sure that's specific to death penalty cases.
It is a death penalty case, Your Honor, and I have not found any cases that have applied it to anything but death penalty cases.
Let me ask you hypothetically, if your client had been convicted of the lesser, and given our decision in Todd, wouldn't you be here arguing that conviction can't stand, in that it was an illegal instruction and we can't look at that? I mean, we can't. The law of the state would not was violated. Where would you be if had he been convicted of the lesser?
I think from our vantage point, the elimination of lessers for felony murder should not be, number one, applied retroactively. We also believe it does violate due process. As I said, I have not found any cases where they talk about that in non-capital cases. But the concern was where you have serious crimes that are committed, no doubt that serious crimes are committed, and the jury only has the option of guilty or acquittal. And in Beck, what they talk about is the concern that would kind of warp the decision-making process of the jury, because they would not want to let somebody go free when there's a very serious crime. We're talking about felony murder, which I believe also is a very serious crime. It's not a capital case. But for those reasons, we believe that the elimination also violates due process. So from our standpoint, he should get those lessers. And I don't know that we'd be arguing here that if he was convicted of the lesser, that verdict can't stand. That is hypothetical. If he would have gotten convicted of the lesser, maybe he would not have appealed. I don't know. But again, going back to our basic premise, I think lessers are warranted in this case and should have been given as they were.
Any more questions? Thank you, counsel.
Thank you.
Thank you, Chief Justice Barry Disney, Assistant Riley County Attorney for the state. I think it's been said that I argued that if you find him not guilty. But I think that if you look at what I said in closing, I just really wasn't tight with my language. And I had this in my brief, but I start off, I said, Judge Stutzman's given you the instruction, and I refer the jury to the instruction, and I said, and it says, if you do not agree that the defendant is guilty of first-degree murder, then you consider the lesser. I read the instruction to the jury. I then turn around and I say, the point being you only look at the lesser, the point being you only look at second degree, and you only look at involuntary if you have found the defendant not guilty. I then turn around and say, and this is really within seconds, so you start with first degree murder by the instruction of the judge, and only if you do not agree do you go on. So, I mean, the problem is that I said you do not agree, then I said only look at it if you do find him not guilty. But I certainly didn't only say you only look at it if you find him not guilty. And I admit, and I admit in my brief, I wasn't tight with my language. But I think when you look overall, I counted up last night the number of times, given the jury instructions and given what I told the jury was told 3 times in the instructions, if you do not agree. And I told them twice, if you do not agree.
Yeah, I think the problem is
As a prosecutor, you know that in order to have a not guilty verdict, which there's 3, in this case there were probably 4 choices on the verdict form: guilty of first degree felony murder, guilty of second degree, and then involuntary, and then not guilty. In order to check not guilty, it has to be unanimous. And I think that's basically the argument.
Right. I mean, and I agree that my language wasn't tight, and
Right.
it should have been, and lesson learned.
Were you the prosecutor in State versus Aguirre,
Yes.
Riley County? Yeah, we had the same problem here,
Right.
so maybe we ought to type this up.
Right. Well, I think if you see me with this after these arguments, then there'll be something. But I mean, the lesson's been learned, and I just used it interchangeably. But I think that to draw from that the prosecutor had ill will, it's just not there. I mean, I've read him the instruction, and I just don't see how you can say that or how a court can say that is ill will when I'm trying to draw the jury to the instruction. It simply wasn't a misstatement. I mean, we saw in the case previously where, the judge said it's not likely or likely, and I mean, it's just one of those things that it's you get caught up on when you're speaking in front of a live audience. So,
What is the effect of State v. Todd on this case, or is there one?
well, State v. Todd is basically gives you the harmlessness. I mean, there is this case. What I said, if it is misconduct, it's harmless because he's not entitled to the lesser. I think there was a little question about why in the world did we even give the lesser. I would tell you that the trial started on Monday morning on June 28th, or I'm sorry, June 24th. And before it started, the defense attorney fell ill with a medical emergency. So it had to be continued to August. Well, July 1st is when the case came out. So when we were arguing instructions and looking at instructions, we didn't have the benefit of State versus Todd. But we knew that new language, the new legislation had come out. But we also had the State versus Wells, which had said that the earlier legislation that made it retroactive, or that the earlier legislation did not make it retroactive. So it was simply a case where we weren't sure whether what the court was going to do.
What was the effect of the legislation that eliminated lesser included offenses for felony murder? Did that redefine the crime? Is that defining a crime when you say it does not contain any lesser included offenses?
You know, I'm not sure how to answer that. I don't think it redefined the crime. As I understood it, it said it is first degree murder. It's a different theory, if that makes sense.
Well, we've said it's an alternative means of committing first degree murder, but Barry said that you apply the lesser included offense statute, and so it can include lesser degrees of homicide. That was our case law, and when the legislature says it no longer includes any lesser degrees of homicide as in conformance with our lesser included offense instructions, to me it redefined the crime
Okay.
as not including lesser degrees like every other. For instance, the alternative means of premeditated still includes lesser included offenses.
Right. And that legislation only applies to the felony murder. And if we had to do this again, we certainly wouldn't have given the lesser based on State versus Todd. We just didn't have the benefit of that. I do think, though, that if you want to say, okay, this is prosecutor misconduct, then it really comes down to a harmlessness error. And I'm not, I don't want this court to find it's prosecutor misconduct, because I don't think it was anything more than just inartful language. But there are lots of reasons why this is harmless. One, because of State versus Todd. But two, also, it was State versus Hurt. The defendant was convicted of the felony murder. And the evidence of guilt was overwhelming. In this particular case, the defendant, at trial, the defendant took the stand and admitted that he fired his weapon 20 to 27 times from his car. It was undisputed that one of those bullets struck Frederick Beverly Jr. in the head and killed him. And this entire incident was captured on videotape. Finally, we had a diagram that the defendant had drawn where he made a big X and said point of aim. So, the felony being shooting at an occupied building was undisputed. We had an exhibit that the defendant had written point of aim on the wall of the building. He admitted to firing the shots. There was no dispute that Mr. Beverly died because of that.
When was that diagram created?
Excuse me?
When was that diagram created?
When was it created? It was created when the defendant, I don't know the date. It was created after the fact, obviously, but it was created for his psychiatrist.
For a psychiatrist.
And it was admitted into evidence through the psychiatrist when the defense called the psychiatrist to the stand. But of course, the jury could use that for that purpose. I believe the defendant was cross-examined on that. I'm not totally 100% on that. But there was just simply no element that was at issue. He admitted to shooting at the building, had a diagram that said this is where I was shooting. He admitted firing 20 to 27 times, and there's undisputed Mr. Beverly died. There's just no way that this jury was going to find him guilty of a lesser if they followed the order. And really, if you look at another thing, when you look at whether there was ill will on the prosecutor, I mean, I read the jury the instructions and I said, so I think I've made my point, let's move on. And then I moved on. But when you look at what the defense did in closing, they didn't even attempt to say why he's not guilty of first-degree murder. They basically said, you know, you can hold him accountable. There's a crime that fits. Find him guilty of second degree. And the problem is, and if a jury starts backwards and works their way up, looking at involuntary and second, I mean, because they're lesser, yeah, he's guilty of involuntary. He's guilty of second. You can't start from the bottom and work your way up. You got to start from the top and work your way down. And really, essentially, what the defense attorney was arguing was jury nullification. Is there's a crime that fits, find him guilty of second. And so when you're considering whether the prosecutor had ill will, I mean, the reason I had to go back and revisit it is say, no, you've got to start at the top and work your way down. It's the only way it works. So I guess unless there's any other questions, that's really all I have.
Just so I'm clear, it was uncontroverted by all the evidence and by the defendant himself that he fired his rifle 20 to 27 times
He admitted that on the stand. Yes.
into an occupied building.
He admitted firing his rifle 20 to 27 times. He said in the general direction of the building on the stand. Then there was a diagram that he had made for his psychiatrist where he had point of aim was the building.
And where was the victim located when he was shot?
The victim, if this timer was the building, there was a fence right to the east, and the victim was probably 20 feet from the building. Basically, the gunshots went from west to east, and the victim was 20 at a gate in the fence and was struck.
And there was some suggestion it may have been a ricochet of a round that was shot at the building and then deflected and hit him?
Right. There was marks. So there's a clubhouse with a brick building, and then there's a chain link fence, and maybe about 4 feet to the east of the chain link. In the chain link fence is a gate, and the fence was struck numerous times as well. And so the bullet was evidence that the bullet had tumbled and probably hit the fence and struck the victim in the forehead. But to answer your first question, there's no dispute that he was firing at the building.
All right, very good. Thank you.
Any other questions? Thank you very much.
Thank you, counsel. You reserve 3 minutes for rebuttal.
Unless there are other questions from the court, I would waive my rebuttal.
Any further questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. At this time,